the evidentiary hearing regarding an alleged violation of the court's personal protective order that was filed on or about June 10th of 2024. At this time, I'd invite Mr. Hengeveld. Would you like to place your appearance on the record?
Yes, good afternoon, Your Honor. I'm Jeff Hengeveld on behalf of Sarah Fazio.
Thank you. And Mr. Cooper Keel, would you please state and spell your full name for the record?
My name's Nevin Cooper Keel. First name spelled Nevin, last name Cooper-Keel.
Thank you, sir. And Mr. Hengeveld, this is your hearing on the alleged violation, so you may proceed.
Thank you, Your Honor. I have one witness to call, and that is Ms. Fazio. Ms. Fazio, can you please tell the court who you are?
My name is Sarah Fazio. My last name is spelled Fazio. I am the petitioner in this matter.
Okay, and are you a licensed attorney?
Yes, I am. I've been a licensed attorney for 24 years.
All right, and how did you first come to know Mr. Cooper Keel?
I sent him a cease and desist letter on behalf of the client I think it was on June 23 of 2022.
Okay.
That was the first interaction I've ever had with him.
And in response to your cease and desist letter, what was Mr. Cooper Keel's reaction?
He sent me a series, several, I don't know if I have the exact count, of emails to my office email address that were a little unhinged and made little sense. I did respond to, believe the first one, if I recall correctly, instructing him not to contact my elderly client and to please direct future correspondence to me. He then proceeded to send me several threatening emails that he was going to sue me, he was going to sue my law firm. I ignored those to my best of my ability. And then he started up again in, I believe, January of 2022 or 23, I'm sorry. I started receiving a litany of additional emails that were more unhinged and more, that he was coming to my office and I was going to get something from him and that sort of thing. And that's when I initially filed for the PPO.
And under that PPO, the terms of the PPO, what is Mr. Cooper Keel prevented from doing as it relates to you and contact with you?
He is not to have any contact with me. He's not to reach out to me in any way, not to send me things, come to my home, come to my office, appear within my site, that sort of thing. Okay.
And now we're here today on the motion to show cause for violation of the PPO, and I want to cover the factual basis for that motion. Were you represented by counsel in a lawsuit that Mr. Cooper Keel filed against you in Allegan County Circuit Court?
Before we dive into this courtroom chaos, let's set the stage, because trust me, this one spirals fast. What we have here isn't just a simple PO violation hearing. It's a full-blown collision between a lawyer with 24 years of experience and a defendant who seems determined to make every possible wrong move. Imagine being so determined to defend your mom that you end up firing off a chain of unhinged emails, threatening lawsuits, and ultimately earning yourself a protection order from an attorney who was literally just doing her job. And that's only the prequel to the mess we're walking into today. The twist? The alleged violation isn't about showing up to her house or calling her directly. It's tied to court filings, appeals, and a very questionable decision to bypass her attorney and send inflammatory documents straight to her inbox. If you think court proceedings are dry, think again. We've got rants, accusations, references to public executions. Yes, you heard that right. And one defendant who seems convinced.
Ms. Fazio, and I'm laying the factual foundation for why there is to be no contact directly with Ms. Fazio in that lawsuit.
Insofar you're laying it in that your argument's going to be, well, that contact should flow through you as the attorney.
Yes.
All right. Response, Mr. Cooper Keel.
My response is that the Michigan Court Rules, Chapter 7, section 2 for the appeals court says that until an attorney files an appearance in that case, they are not representing the client. So for that to be relevant, he would have to be representing her in that case, because I think what they're getting at is that I served a copy of a motion from an appeal where she was not represented, not this other case he's asking about. So I don't see the relevance of the other case.
Okay, and response on wrong case argument, Mr. Hengeveld.
Yes, Your Honor, I was always the attorney for Ms. Fazio in her capacity as it relates to the lawsuit out of which the appeal arises. There was a motion for reconsideration filed. Whether it's my strategy or not to respond either to claim for interlocutory appeal or to not respond to a motion for reconsideration because it's not required to be responded to or not allowed to be responded to under the court rules. All of that doesn't obviate or vitiate my appearance on behalf of Ms. Fazio, my representation of Ms. Fazio. If that were the case, then you could make contact directly with a party and when they were represented by counsel. Clearly, that's not what the appearance rules require or provide for. In other words, I'm the attorney for Ms. Fazio.
One of those moments where the formality of the courtroom stands in hilarious contrast to the absolute absurdity of what's coming. Everyone is calm, professional, following procedure, but beneath that smooth surface is a powder keg. You can almost feel the judge bracing himself when he asks the defendant to spell his name, as if mentally preparing for whatever unpredictable twist is coming next. And keep an eye on how the defendant behaves from the start. The tone, the objections, the immediate pushback. It paints a picture of someone who's not just unfamiliar with courtroom etiquette, but actively convinced he knows better than the lawyers and the judge combined. What we're about to see is a classic example of how representing yourself can go catastrophically wrong, especially when your strategy is built on misinterpretations of procedure and a person.
The district court or the Elegant Circuit Court or the Kent Circuit Court is not the controlling factor there. It's the representation itself. I'll overrule the objection and allow the response.
All right, so the question again, Ms. Fazio, was, were you represented by counsel in the lawsuit that Mr. Cooper Keel filed against you in Allegan County?
Yes, I was. You were
Who
my
was your counsel?
You were in Price Hunteville.
Okay. And as it relates to the claims against you in that lawsuit, what was the outcome?
I should say Plunkett County. I apologize.
Okay.
What was the outcome? The outcome of the underlying case in the state court was dismissed.
Okay. And then it was subsequently taken up in an interlocutory appeal?
That's my understanding, is that it was taken up in an interlocutory appeal. That's correct.
Okay. And what is your understanding of the outcome of that interlocutory appeal?
It was denied.
And after it was denied, and again, I'm going to show you momentarily your some exhibits, but after it was denied, the interlocutory appeal was denied. Do you know whether Mr. Cooper Keel filed anything further to address that denial?
Yeah, I believe he filed, and I can't remember what the document was called, but he filed a late document, or motion for reconsideration, I believe is what it was entitled, or something to that effect.
Okay.
With the Court of Appeals.
Your Honor, I can either put it up on the screen if you allow me to share my screen, or I can just reference it. These are just the exhibits to the PPO motion. What would Your Honor prefer?
Why don't you go ahead and display it on the screen?
All right.
Where the judge and us start getting the full picture of why this PO exists in the first place. The attorney describes a pattern that's not just annoying or rude, but escalating and obsessive. Multiple emails, increasing hostility, threats of lawsuits, and even hints that he'd show up at her office. These aren't things a court can ignore. Notice how composed she is while recounting it. She's a seasoned attorney. She's likely seen absurd behavior before. But the fact that she felt the need to file a protection order, that tells you this wasn't just unprofessional behavior. It crossed into genuinely concerning territory. The audience should be asking, if this is how he responded to a simple cease and desist letter, what's he capable of when he feels?
June 11, I printed that off the day after I received the 11-something p.m. email from you. So it was June 11 that I printed it. I don't know on the register of actions. If he was ever added, I think it just comes up from the state court as every attorney that's of record in the state court.
Okay, so that was a register of actions from the state court, not the Court of Appeals.
No, that
Correct.
was just, nope, that's wrong. That was a register of actions from the Court of Appeals.
Can your attorney put it back on the screen and show it to me? Because first time I've ever seen that.
Raises a relevance objection, which, to be blunt, is almost never a good idea when you're the one accused of violating the order. The judge gives him space, but you can tell the objection is already hanging by a thread. What happens next shows the strategic divide. The attorney frames everything in the context of legal procedure, representation, and professional norms. Meanwhile, the defendant clings to one narrow interpretation of court rules as if he's discovered a secret cheat code. It's a classic pro-SE pitfall, knowing just enough terminology to sound confident, but not enough to be correct. This objection sets the tone for the rest of the hearing. A man trying to out-argue the system while the system...
Mr. Cooper-Keel?
I don't recall when it's been asked and answered. In fact, they claimed that he represented her, but
Yeah,
they
he
don't
elicited
say that.
testimony that he was the attorney. Are you asking something different then?
Yes, I'm asking, when did he file an appearance?
I already
And
answered.
And she
you're
already,
referring to the appeal in this matter.
All
Is
right,
that-
yeah.
I don't want to put words in your mouth. You might
She doesn't
say
know.
that.
She said she doesn't know when.
Okay.
So I guess, yeah, that's, I don't object or, want to push against the objection. They're right. Asked and answered.
You may continue, Mr. Cooper-Keel.
Here is a masterclass in how an experienced lawyer dismantles a flawed argument without ever raising his voice. The defense keeps insisting that because the attorney didn't file a formal appearance in one specific venue, he was suddenly free to contact her directly. But the attorney calmly explains, representation exists outside of a single docket entry. If you know someone has a lawyer, you can't bypass them. Period. And the judge agrees. This is important. The court isn't just ruling on paperwork. It's ruling on knowledge and intent. If the defendant understood she had counsel and still sent documents to her directly, that's exactly the behavior PO orders are meant.
From the moment there was a Court of Appeals action.
For an attorney to appear for somebody, don't they have to file an appearance?
she asks for a legal conclusion.
All I know is that he appeared as counsel of record from the moment I saw the docket at the Court of Appeals.
How did you get the register of actions from the Court of Appeals?
It's available online.
Where at online?
I'd have to go look up the URL. I don't know.
Okay. I'm just wondering where that came from, because I don't know how to get one for the Court of Appeals.
Is there a question?
How do you get the list
I
of
already-
register of actions?
Your Honor, she already testified. Objection asked and answered. She already testified. She does not know. She would have to look up the URL, which is not on Exhibit B.
Okay, and I did hear that asked and answered before, and she said she doesn't know as we sit here today. So you may move on to your next question, Mr. Cooper-Keel.
So how do we even know that register of actions came from the Court of Appeals?
Because I obtained it from the Court of Appeals website. On June 11 of 2024.
Do you think it's possible maybe it's showing the lower court register of actions rather than the one for the Court of Appeals?
No.
Okay. So you said your first contact with me came in 2022 when you sent a cease and desist letter on behalf of your client, right?
Correct.
And I responded to that email asking you, how do you think I am harassing or trespassing on your client's property? Because wouldn't I have to first be doing something to cease and desist it, correct?
I don't recall every word of that email. Do you have a copy of it?
Yes, I do.
Okay.
Would you like to adjourn for?
No.
And isn't it true you didn't respond with anything to my request for you to describe how you think I've even been doing that to cease and desist it?
Objection relevance, Your Honor.
Okay, response on the objection to relevance, Mr. Cooper Keel.
Well, what she said about her email contact with me in 2022 is completely false in her own direct testimony. She said I sent threatening emails then. Now she doesn't remember what even was sent.
Your Honor, may I respond?
You may.
Well, while it's accurate that I did ask a question about, I guess, the foundation for the PPO, or at least my intent to lay a foundation for the PPO, and we're not here to relitigate whether the PPO was properly issued, and we're not here to relitigate the case against that Mr. Cooper Keel had filed against Ms. Fazio's client in that lawsuit. So that's why I object on relevance.
Okay. Well, the question of relevance is with regard to are the prior emails and the content of those emails relevant? I think their existence is relevant because, after all, these violations would have come via an email notice of this register of actions. However, the content and the reasons they were utilized as the basis for the PPO are not relevant to today's hearing. I'll sustain the objection and ask that you move on to your next question, Mr. Cooper Keel.
Okay. Then in 2023, in your direct testimony just now, you claimed I said to you I was coming to your office. Is that correct?
Something to that effect, yeah.
Do you have any copy of any email saying something to that effect?
The emails that are the basis for the PPO that were received in January of 2023 from you were attached to the PPO application. I don't have it in front of me, but if you want to show it to me, I'm happy to talk about it.
Start to see a pattern. Every legal avenue the defendant has pursued has been dismissed or denied. His lawsuit? Dismissed. His appeal? Denied. His motion for reconsideration? Likely denied as well. And every time the court says no, he doesn't step back. He escalates. That's a giant red flag. Courts expect emotional maturity, even when the outcome isn't what you want. But instead of accepting rulings, he keeps pushing, filing, arguing, and, as we're about to see, lashing out in writing.